Lawyers can be like dentists. When you go to a dentist in a time of crisis, you will get necessary but unpleasant help. When you come to a lawyer at the time of a serious data breach, you will get necessary help, but it can often be an unpleasant experience. And that's because of the exposure to legal liability. And that is the subject for today's TDW Tech Bite. So in the data breach response, the primary role of the lawyer is to manage, advise on, and try to mitigate legal liability. Liability in respect of any legal claims is not the only concern that a business will have. This has to be brought into the context of the broader issues that are going on in the business as it responds to this serious situation. But good, clear advice on the types of liability that can arise and the actions to be taken to try to mitigate those risks is absolutely vital. Now, the subject is too broad to discuss in the course of just this short video alone. But let's break out the types of liability into three categories to give a framework which can help you to understand more about this subject. First, there is criminal liability. Now, criminal liability can arise because there's a direct criminal offense related to particular matters within the scope of the data breach. This can happen in jurisdictions where there are specific cybersecurity frameworks. However, more likely is the case where there would be a criminal response or a criminal offense in situations where you have refused to comply with directions given in the course of an investigation. So basically, obstruction of justice. If you're in a situation where you're committing offenses of that nature, the consequences can be severe not only for the company, but also for officers of the company, like directors, who are complicit and responsible in respect of those particular actions. For the most part, businesses are really concerned about administrative fining powers of regulators. Now, this is different to a criminal liability. You don't go to prison if a regulator imposes an administrative fine. However, the scale of administrative fines is increasing if you look at the way that laws are trending around the world. For instance, in the EU, GDPR had made significant waves by introducing turnover fines that at their most severe could account for 20 million euros or 4% of the global turnover of a business. Those kinds of fines can be mouth-watering, and there have been some very significant fines imposed for data breaches in the EU. What does this mean? It means that if you're in a jurisdiction where the regulator has administrative fining powers, then you need to look carefully at the factors that the regulator will take into account in the course of its investigation, and also how you respond to the regulator in the course of that investigation. That does not necessarily mean waiving legal professional privilege and disclosing matters that you shouldn't necessarily disclose, but it does mean being transparent, cooperative, responsive, helpful, and supportive, with a primary focus on remedial action to mitigate the extent and scale of the impact of the breach on data subjects and other persons who may be harmed. If you deploy those kinds of factors and responses, then any negative outcome may be mitigated by the fact that you have behaved responsibly in the course of that investigation. Although we say that data breaches and security incidents are inevitable, and it is a question of when, not if, this will happen to your business, nonetheless, one of the important factors in any regulatory investigation that goes right to the level of fines that may be imposed is the extent to which you have processes that are adequate and appropriate, that are intended and designed to safely secure personal data and other important data from unauthorized access, use, disclosure. Those processes must be actively enforced, communicated, and educated in respect of the people within the community who have access to that data in question. These are the kinds of things that a regulator will look at. They will look at reporting lines right to the board level to ensure or to assess whether or not there has been proper attention given to information security within the business, with the proper deployment of resources to support the policies and procedures that are necessary. The regulator will also look at how quickly and how effectively you responded to the incident in terms of assessing the risk of harm, making notifications that may have been necessary or prudent, and then cooperating with the regulator. Now, where I sit in Hong Kong, there aren't administrative fining powers for our regulator here. But change is coming, and there are plans announced to change the laws, to introduce administrative fining powers based on turnover in Hong Kong. And this is true of many jurisdictions around the world already. The third category of liability I wish to address today is civil liability. Now, this can arise in a number of ways. Firstly, data subjects will often have an individual right that is preserved in any data protection laws to bring civil claims to seek to recover damages for any loss they have incurred by reason of a data breach. These individual claims can often be rather remote as a risk because personal data breaches, it is hard to establish direct consequential loss to the data subject, to the individual. In some jurisdictions, there are class actions where a group of plaintiffs accumulate their claims together and bring that against the company in question. But class action litigation isn't recognized in all jurisdictions around the world. So, for instance, here in Hong Kong, class actions would not be generally recognized before the courts. If there aren't class action remedies, then the individual right of action is not as effective as it could be. This is the reason why you have strong regulation and administrative fining powers. It acts as a counterbalance to ensure that there's a proper enforcement mechanism to enhance data protection within that jurisdiction. Perhaps a more critical or close risk of civil liability for a business is the contractual liability that might arise in respect of people with whom the business is contracting, particularly through the supply chain. If you have a data breach or a data loss, the consequences of that may be quite significant to other businesses that you interact with. This could be covered by your contracts with them, or the claim could also arise in tort or in negligence. This contractual risk is something that a legal team would immediately seek to review in the course or in the immediate aftermath of a data breach. Now, that is a whistle-stop tour of the potential liabilities that may arise in respect of a data breach. The issues are far more complex, and this is one of the areas in which you should immediately seek external legal counsel from experienced litigators or regulatory lawyers who have the experience in dealing with investigations and responding to claims of this nature.